At the most basic level, a will is really just a set of instructions that details for someone who you nominate as an executor, also called a personal representative, about how to distribute your assets when you die. So the will is really just a dormant document until it is authenticated by the court. That is the probate process in essence. The court looks at the will, says, yep, this looks authentic, puts its stamp on the will, it's admitted to probate. As part of that process, the court appoints an executor, like I said, also called a personal representative, and that person is then in charge of administering your estate and carrying out the terms of your will. An executor actually doesn't have any authority until the court appoints them. Your will is simply a nomination of who you want. A will often doesn't control all your assets. If you have beneficiary designations on bank accounts, retirement accounts, life insurance accounts, those beneficiary designations essentially trump the will. If you have assets that have beneficiary designations on them, it's important that they work in concert with what your will says, that those two things work together. I always like to use the example, say you've got two kids, your will says everything equally to those two kids, but you have an IRA over here that only has one kid as the beneficiary. In the end, you might not have an equal distribution between the two kids. Your one kid's going to get the $400,000 from the IRA, but they're going to split everything that is under the control of the will. So you have to make sure that both kids are on the IRA and both kids are in the will as equal beneficiaries if you want them to truly share equally. A will and a trust are both ways to direct how your assets will be distributed after you die. Now, there are lots and lots and lots of kinds of trusts, but in this circumstances, when we're comparing a will to a trust, we're generally talking about a revocable living trust. Revocable living trusts are most often used as a probate avoidance tool. They can help you avoid going through probate. In other states, this is very important. California, for instance, probate is a terrible process. It takes forever, really costs a lot of money. Washington is kind of on the other end of the spectrum. Probate is relatively streamlined, doesn't usually cost much more or any more than a trust administration. So in Washington, we don't use revocable living trusts all that often. Certain circumstances still do necessitate the use of them, but usually using a will is simpler and more cost effective. Even though we're in Washington with a relatively streamlined probate process, a revocable living trust can offer a few advantages. Say that you have a lake cabin in Northern California. Well, you can place that cabin as an asset to be owned by the trust, and then you can avoid probate in California, where it's not nearly as streamlined as in Washington. Trust administration or using a revocable living trust is also a private process. The courts are typically not involved. And so if you want the administration of your estate to be a private affair, you don't want anybody to have any access to how your assets are going to be distributed, you can use a trust.